Good afternoon again, everyone. Just so we all are aware, we have started the YouTube stream. And can you all remember to change your names in your Zoom so we can identify the party and the advocate? Hello again, everyone. It looks like we're just waiting on one more person. Defense, we're looking for Officer Wentz, I believe, was identified on a witness disclosure form.
Your Honor, I also want to let you know that our timekeeper and tech person is having trouble logging in for the state.
Your Honor, Officer Wentz is also having the same issue right now. He's working on getting into the courtroom.
Thank you for the update. See what I could do from my end. So if I understand, we're still waiting on a tech from the defense as well as Officer Wentz.
It's a tech for the state, Your Honor.
Just tech for the state. Do you see Officer Wentz has joined us? So we're just waiting on the tech. Okay.
And I see our tech has just joined us, just hasn't yet renamed herself.
Excellent. We're just waiting on the all clear from the appellate court at this point. There's still a few jurors moving around in some other courtrooms, so we should be good to go in just a few more minutes. I appreciate everyone's patience. Okay, we got the all clear to start. So now calling case number 98-2018, the state of West Carolina v. Timothy Ray. Are the parties ready to make their appearances before the court?
Yes, Your Honor. Good afternoon. My name is Carly Gubernick, and I, along with my co-counsel,
Good afternoon, Your Honor. My name is Alan Carlson.
we are Team 112, and we're here representing the defendant in today's case, Mr. Timothy Ray.
Thank you, defense. And for the people?
Good afternoon, Your Honor. My name is Madeline Chandler, and along with my co-counsel, Joe Soloway, we represent the people.
Good afternoon, Your Honor.
Good afternoon, everyone. And any pretrial matters before we need to address before getting into opening statements?
Yes, Your Honor. The people have a couple of pretrial matters to address whenever you're ready.
Okay. Do you have any motions in limine?
We do, Your Honor.
Let's start with your motions then.
Okay, my co-counsel will be handling the motions.
Thank you, Ms. Chandler.
Your Honor, we have one substantive motion in limine and one stipulation to draw Your Honor's attention to this afternoon. But before we get to that, let's to provide Your Honor with some context for this case. This is a case about a man who lost his temper when his 6-year-old son would not stop screaming for his mother. As a result, that man wrapped a belt around his son's neck and strangled him to death. Your Honor, these facts are not in dispute here today, and instead the defense has brought an insanity defense in this case. Your Honor, the defendant in this case did not show signs or did not claim any signs of schizophrenia prior to killing his son. However, after killing his son, he began to claim signs of delusions and hallucinations once it became clear that the police were going to arrest him. With that in mind, I would first like to draw your attention to a stipulation in this case. That is stipulation 4 on page 5 of the evidence.
Before you get any further, Mr. Soloway, does the defense have anything they'd like to add to the people's statement of the case at this point?
Yes, Your Honor. We do have one. We do just want to clarify that the state just said that the facts aren't in dispute. And in part of what they said was that the defendant lost his temper when his son was screaming for his mother. We just want to clarify that that fact is in dispute. It is absolutely in dispute whether or not the defendant lost his temper. Your Honor, in this case, the jury will hear about a man who was suffering from schizophrenia when he killed his 6-year-old son. Now, we don't dispute that Timothy Ray physically caused the death of Nathan Ray. The legal issue before the jury is whether or not we've proven by clear and convincing evidence the insanity defense today.
Okay, so you're not contesting the actual, the killing itself, is that correct?
We're not contesting the physical killing itself, Your Honor, yes.
Okay, I understand. Mr. Soloway, I understand you have a stipulation you'd like to point out?
Yes, Your Honor. On page 5 of the evidence packet, I just want to make sure, does Your Honor have a copy of that evidence packet?
I do, yes.
On page 5 of that evidence packet, stipulation 4 specifies that exhibits 6, 7, and 8 are admissible with no further objections. This includes objections for lack of foundation. For that reason, the state moves to enter exhibits 6, 7, and 8 into evidence at this time.
Okay, defense, anything I need to know in addition to exhibit 4 is as stated? Or stipulation 4, excuse me.
No, Your Honor, by stipulation, those are admissible today.
All right, 6, 7, and 8 will be admitted onto the record. Mr. Soloway, I understand you also have a motion.
Yes, Your Honor. We have one substantive motion today, and that concerns is to exclude statements made by an Officer Cruz. Your Honor, in 2010, the defense expert, Dr. Riley, examined the defendant. In his report, he included a statement by this Officer Cruz that Officer Cruz believed that the defendant was having visual hallucinations. Your Honor, we move to exclude this on the ground that it is a lack of foundation. If I may make an offer of proof.
Before you do, defense, do you plan on eliciting any testimony from Officer Cruz?
We don't.
Go ahead.
I'm sorry, continue.
Yeah, for you, counsel.
There are statements that were made by Officer Cruz that do play into our case today that we would argue against their exclusion.
Okay. Mr. Soloway, why do you think I should keep these statements out?
Yes, Your Honor. The only information we have from Officer Cruz is a bare statement of opinion that the defendant was suffering from these visual hallucinations. There is no evidence in the Dr. Riley's report about any specifics regarding the reasons that Officer Cruz had this belief, any conversation Officer Cruz may have claimed to have with the defendant, any behaviors that the defendant was exhibiting. Because we don't have that foundation as to why Officer Cruz believed that, this is inadmissible under Rule 602. Further, Officer Cruz is dead, so we have no opportunity to get that information. We have no opportunity to cross-examine or really do anything with this apart from it being admitted. We have a good faith belief that the defense is going to attempt to admit it through their expert, Dr. Riley. It's a statement of belief about something going on in someone else's head without any basis of behaviors or statements made by the defendant, and therefore it should be excluded for lack of foundation. We recognize that because it's an expert involved, 703 may also have application. I can go into that if you like, or I can reserve that for pending your determination regarding its inadmissibility.
First, let's hear from Ms. Gubernick. Will you be arguing the motion for the defense?
Yes, Your Honor.
Do you have a position?
Yes, I do. It's our position that under Federal Rule of Evidence 602, these were statements made based on Officer Cruz's personal knowledge and what he experienced as being being Mr. Ray's commanding officer in the United States military. Further, he gave these statements to Dr. Riley, who then used those as motivation for the psychiatric evaluation that took place back in 2010. Further, under Federal Rule of Evidence 703, this information was included both in the psychiatric evaluation back in 2010, as well as in Dr. Riley's report, which was relied on by both experts who are going to testify in today's case, which is why we believe that Officer Cruz's statements should be admissible today.
Mr. Soloway, do you have a response to the argument that this will be one of the basis of the expert's opinion here today?
Your Honor, we have no opposition to the fact that the expert used it as a basis for opinion. We simply wish to keep the jury from hearing the specifics of this statement. Your Honor, under Rule 703, the standard is that the probative value of otherwise inadmissible evidence must substantially outweigh the prejudicial effect. Here, the probative value, given this lack of foundation, given the fact that just because Officer Cruz was the defendant's commanding officer, we don't even know how big a unit this was, how close that relationship was. All we have is this one specific statement of belief. So the probative value is exceptionally low as to the trustworthiness of this evidence. And as to the unfair prejudice here, Your Honor, we have no opportunity to cross-examine on this. It simply doesn't exist because Officer Cruz was deceased prior to the events that brought us to trial here today. Therefore, it does not meet the 703 test to be admissible despite it being otherwise inadmissible, and it is inadmissible under 602 for lack of foundation.
I understand the state's concern, Mr. Soloway. As you know, that's a very fact-specific argument, so I'm going to reserve my ruling on the evidentiary admissibility of this testimony at the moment and allow Ms. Gubernick to attempt to lay the proper foundation for all of this through her expert witness. Does the people have any additional motions to raise at this time, Mr. Soloway?
No, Your Honor, the people are ready to move into preliminary matters.
Excellent. Ms. Gubernick, does the defense have any motions they'd like to bring at this time?
We do, Your Honor. We have one motion for you, as well as 3 stipulations to bring to Your Honor's attention.
Why don't we start with the stipulations, actually?
Sure, no problem. So we met with counsel pre-trial, and they agreed that the prosecution will not be eliciting any testimony that talks about the fact that as defense counsel, we did not allow Dr. LaGreca to interview Mr. Ray in this case.
Mr. Soloway, so stipulated?
Your Honor, I just want to clarify, as part of that stipulation, it was agreed that the defense would not bring up the fact that Dr. LaGreca did not have the opportunity to speak to the defendant.
Absolutely.
Okay, sounds like we have an agreement among the parties.
Yes, Your Honor.
Yes, Your Honor.
Ms. Gubernick, any other stipulations?
Yes. We also, during our pretrial conference, we also agreed that under Federal Rule of Evidence 704B, as well as the Pasquarella case, which is binding precedent in this jurisdiction, no expert may give any opinion on whether Timothy Ray did or did not have intent to kill, or did or did not know right from wrong at the time of Nathan's death. That's understanding that under Pasquarella, experts can testify to generally disorders that may be able to may affect someone's ability to tell right from wrong, but that testimony will not be specific to Mr. Ray in this case.
Mr. Soloway, is that an accurate summation of your agreement as far as you're concerned?
Yes, it is, Your Honor.
So stipulated, and we will move right on. Ms. Gubernick, I believe you said you had 3 stipulations?
Yes, one last stipulation. The prosecution has agreed that they will not be using Exhibit 27 in this case, so that we have stipulated that will not be coming in today.
And just so, for my own personal knowledge, what is Exhibit 27?
Exhibit 27 is a photo of Nathan Ray's bedroom.
Okay. Mr. Soloway, so stipulated?
Yes, Your Honor, and if you'd like to look at it, it is located on page 104 of your evidence packet.
Thank you. Ms. Gubernick, I understand you have a motion as well.
Yes, Your Honor. So there's one other photo in this case. It's a photo of Nathan Ray. That's Exhibit 27. We moved to exclude this photo under Federal Rule of Evidence 403 because, again, as we said, the only legal issue for the jury to decide in this case is whether or not we have proven the insanity defense by clear and convincing evidence. Showing the photo of Nathan Ray only serves to ignite the jurors' emotion and detract from their ability to do their job today, which is to determine what Timothy Ray's mental state was 2 years ago when Nathan Ray died.
Mr. Soloway, do you have a position?
Your Honor, Nathan Ray is the victim in this case. Under Rule 403, the probative value must be substantially outweighed by the danger of unfair prejudice. Your Honor, in order to understand what happened and to help the jury understand the exact actions that Mr. Ray took, which can speak to his mental state, the jury needs to understand exactly how the killing of Nathan Ray took place. It's a harrowing case. That's going to potentially, it's going to be a hard thing to hear. This photo doesn't add any unfair prejudice to that. It's a picture of the victim. It's also probative because even if the defense does not intend to present evidence of opposing the identification of Nathan Ray, we do still have a burden here today because the defense has not stipulated specifically to that fact.
Your Honor, if I may.
Please.
Again, we don't argue that Timothy Ray physically caused the death of Nathan Ray in this case. Showing the photo doesn't give the jury anything in addition to the testimony that they will hear today about the physical acts that led to Nathan Ray's death. Showing a photo doesn't do anything to help with that. Further, because we've already agreed that the autopsy report in this case is admissible, which talks about Nathan's age, his height, his weight. None of that is in dispute today. And that's why we believe that showing a photo of Nathan Ray does just ignite the jurors' emotions, and that does serve to unfairly prejudice Timothy Ray in this case.
At this point, I understand the defense's position. The photo is prejudicial, but I don't believe it's unduly prejudicial, so I will deny your motion. Ms. Gubernick, anything else from the defense?
With that, the defense is ready to proceed, Your Honor.
Okay. Any additional housekeeping matters we need to address before moving into opening statements?
Yes, Your Honor. Oh, sorry.
Go ahead.
I was just going to say that the state does have a couple of housekeeping matters, Your Honor.
And what would those be, Ms. Chandler?
Yes, I assume Your Honor is probably already familiar, but we're using an electronic case notebook, and the witnesses have a copy of this notebook, and we'd just like your permission to refer to the page numbers for admitting the exhibits, ask to admit it, and then publish electronically to the jury, so long as that's okay to for Your Honor.
Yeah, that's great. You could all lay foundation without actually publishing the exhibit.
Yes, Your Honor. We'd also like to make you aware that we plan on using a PowerPoint during our opening statement. We have shown this to opposing counsel prior to today's trial, and it's our understanding they have no objection.
Is that true, Ms. Gubernick?
Yes, Your Honor. We have also shown our demonstratives to opposing counsel, and all have been agreed as admissible.
Excellent. Ms. Chandler, anything else?
Yes, Your Honor. We'll be using a demonstrative during the direct of Dr. LaGreca, shown to opposing counsel prior to trial, and they had no objection to that either.
Okay. Anything further?
Yes. Lastly, Your Honor, the defense and the people in this case agree that the definition of legal insanity listed in the jury instructions is complete and accurate and not in dispute.
Perfect. Anything further from the state then?
No, Your Honor. We're ready to move to opening statements.
Ms. Gubernick, any additional housekeeping matters?
Yes, Your Honor. We just ask that all witnesses be constructively sworn.
Agreed.
And that any sidebar, any time that an objection is asked to be outside the presence of the jury, that sidebar be constructive.
Yes.
And the exhibits in this case have been pre-marked. We ask that as they're admitted that they maintain their pre-markings as addressed by counsel during.
Yes, that'll be allowed.
And then as far as sequestration of witnesses, we just ask that the fact witnesses be sequestered in this case. We know that the experts will be in the room for trial today.
Yes, we will sequester the non-expert witnesses.
Okay, with that, the defense is ready to proceed, Your Honor.
Okay. We will now hear opening statements from each party. Everyone should make sure that they are in speaker view on Zoom. That button is in the upper right of your screen. And attorneys, please remember to mute your audio while the other attorney is speaking.
May I proceed, Your Honor?
Yes, whenever you're ready, Ms. Chandler.
Thank you. I pulled the belt until he stopped screaming, until he stopped moving. Those words, those are the words that came out of the defendant's mouth as he confessed to fatally strangling and ending his 6-year-old son, Nathan Ray's life. On October 17th of 2018, Nathan lay dead on his bedroom floor inside the defendant's home. His life had just been ended by the defendant, his father. See, the defendant thought that Nathan had done something wrong and needed to be punished when he spilt a glass of apple juice that ended up all over his laptop. The defendant began that punishment by making Nathan do jumping jacks. But when Nathan, at just 6 years old, kept screaming and crying, "I hate you! I want my mom!" Those words, those were the last words the defendant wanted to hear. And he walked out of that bedroom, down the hallway, grabbed a belt out of his closet, walked back to Nathan's room, and began spanking him with that belt. And each time Nathan was spanked, he yelled out, "I hate you! I want my mom!" Until the defendant took that belt, wrapped it around his neck, and in his own words, that belt. He pulled on that belt until Nathan stopped screaming, until Nathan stopped moving. The defendant then dropped that belt on the ground and looked over on the lifeless body of his 6-year-old son. The next day, the defendant Googled how to get rid of a body. And then he wrapped Nathan up in black trash bags and buried him in a shallow grave in Brandywine State Park. Members of the jury, nothing that I just told you is contested or disputed in this case because, well, the defendant, he confessed to it. And although unusual, we do not anticipate that the defense is going to stand up here and challenge the fact that it was the defendant who strangled Nathan Ray to death. We also don't anticipate that they will challenge the fact that it was the defendant who was the sole and only cause of Nathan Ray's death on October 17th, 2018, here in Skelton. Rather, what the defense does contend is that the defendant was legally insane when he did these things, which is why you are here today, to determine whether the defendant was legally insane when he strangled his 6-year-old son to death. Now, the judge will tell you that the defendant and his attorneys, they bear the burden in this case of proving that he was legally insane. And to do this, you will learn they have to prove 2 things. The first is that the defendant had a severe mental disease or defect. And the second is that at the time of murdering his son, the defendant was unable to appreciate the nature or quality and wrongfulness of his actions. You will learn this is a 2-part inquiry. The judge will tell you the first part asks you to determine whether the defendant had a severe mental disease or defect. And the second part, it's a bit more complicated. But essentially, what it is asking you is, did the defendant know his actions were wrong as he strangled Nathan Ray? You will be presented with evidence and testimony throughout today's trial that will aid you in answering these questions. Let's start with what the evidence is going to show you in response to the first question. Did the defendant have a severe mental disease or defect? Now, I want to make something very clear. No one here denies the fact that the defendant is troubled. It is not proper or acceptable to murder your own child. But that alone is not sufficient to prove insanity. Rather, the defense, they must prove he had a severe mental disease or defect. You're going to hear from 2 experts in the field of forensic psychiatry, Dr. LaGreca for the state and Major Riley for the defense. Now, Major Riley interviewed the defendant for a couple of hours and came to the conclusion that he had schizophrenia, a mental illness the defendant had never been diagnosed with before and denied experiencing symptoms of. Dr. LaGreca, the expert for the state, analyzed Major Riley's report and the evidence in this case, and he will go through the criteria of schizophrenia with you and explain that the defendant does not meet a single one in order to have a schizophrenia diagnosis. He will tell you the defendant does not have a severe mental disease or defect. You will not hear from a single person today that knew the defendant prior to Nathan's killing, that had ever seen or heard the defendant talk about or experience the severe symptoms he says he has. Which is why Dr. LaGreca will talk to you about something called malingering. And malingering simply means when an individual fakes or exaggerates symptoms in order to gain something. It is often done in the context of a criminal prosecution in which the individual is facing large penalties for their actions. Which leads me to the second question. And again, essentially what the second question is asking you is whether the defendant knew his actions were wrong as he strangled Nathan Ray. You will hear from 2 individuals in law enforcement. The first is the officer that pulled the defendant over after he had murdered Nathan. And you will hear exact statements the defendant made to this officer. Statements like, "I didn't mean it. I messed up." Statements that will indicate the defendant knew precisely what he had done was wrong. You will also hear statements the defendant made to a detective. And this detective will tell you the defendant confessed to him all the details of killing his son and disposing of his body. The detective will also tell you he conducted a search of the defendant's phone. The search will indicate that just after strangling his 6-year-old son to death, the defendant was Googling how to get rid of a body, does bleach destroy a body, and countries that would not extradite him for murder. Just after strangling his 6-year-old son to death, the defendant was looking for ways to avoid the legal consequences of his actions. Because as you will learn, he knew it was wrong to kill his son. The evidence throughout today's trial will show that the defendant is not legally insane. And that is why at the end of today's trial, we are going to ask you to find the defendant guilty.
Thank you, Ms. Chandler. Mr. Carlson, do you have an opening statement you'd like to present at this time?
Yes, Your Honor.
Whenever you're ready, Counselor.
Thank you. Timothy Ray is not a criminal. He is not a father who maliciously killed his child. You see, mental illness runs in Mr. Ray's family, and he has suffered from a severe mental illness for some time now, including extreme paranoia, voices, and hallucinations. And his severe mental illness, his schizophrenia, not only caused Mr. Ray to lose his sanity, but caused a far greater tragedy: the death of his son, Nathan. This is a case about a severe mental illness that went unnoticed, unchecked, and untreated. If today's trial were about whether the death of Nathan was a tragedy, well, it would be over before it even began, because everybody agrees that the death of a child is unquestionably tragic. But today's trial is about whether Mr. Ray is criminally responsible, or whether his conduct was a result of a severe mental illness. And that's what the insanity defense is about: ensuring blame is properly placed on those who understood what they were doing when they were doing it, not on those that suffer from a sickness. Mr. Ray is 34 as he sits before you today, but his history with mental health issues started when he was a kid. At the age of 6, his mother was institutionalized for symptoms resembling that of schizophrenia. By age 10, he himself began to hear voices. And in his 20s, he suffered from depression, anxiety, and eventually extreme paranoia. And this mental illness was active in the years leading up to Nathan's death. In 2015, 3 years before Nathan died, Mr. Ray became paranoid, hearing voices that his wife was cheating on him. A year later, he began to experience visual hallucinations. His wife said he would go weeks without showering. He would often lock himself in the bathroom for hours at a time, refusing to come out. Mr. Ray was battling a serious mental illness, and he was losing. In the months leading up to Nathan's death, a series of events occurred that broke Mr. Ray. In 2018, his wife had an affair. All of a sudden, the voices that had been telling him for 3 years that his wife was cheating on him, well, they were telling the truth. The voices became real. And these voices, they became more frequent, more commanding. The voices told him that his wife and his son were planning to leave him. They told him that his wife was planning to sabotage him. Remember, to Mr. Ray, the voices were correct about the wife's affair. Why wouldn't they be right about this too? Only days before Nathan's death, Mr. Ray's wife told him that she was filing for divorce. She was leaving him. Once again, the whispering voices became reality. And this brings us to the day of Nathan's death. That morning, Nathan spills juice on his father's laptop. The voices tell him it's a trick. They tell Mr. Ray that the juice is part of his wife's plan to split up the family. And so when they tell him to punish his son, he does. But what you are going to hear from Dr. Riley, a psychiatry expert with decades of experience, especially in treating those from the military, is that Mr. Ray was in a schizophrenic episode the day Nathan died. Dr. Riley has personal knowledge of this defendant's medical history. She first treated him in 2010. And Dr. Riley spoke to those that knew Mr. Ray best, his father, his boss, his ex-wife, Nathan's own mother. And the doctor that's treating Mr. Ray right now corroborates Dr. Riley's diagnoses through their treatment and their prescriptions. Dr. Riley found and will tell you using tools of science that Mr. Ray is a schizophrenic, and that schizophrenia is a disease that can prevent someone from understanding the nature and quality of their acts or whether they were right or wrong. The prosecution's case at bottom is that they can prove that this guy is a cold-blooded murderer beyond a reasonable doubt. But you will know that is not true because Mr. Ray was insane. There will be clear and convincing evidence that Mr. Ray suffers from schizophrenia and that as a result of that severe mental illness, he did not know the right from the wrong of what he was doing. Everybody wants justice for Nathan Ray. But that justice is not found by making a criminal out of a man who suffered from a severe mental illness that went unnoticed, unchecked, and untreated. And that's why at the end of this trial, my colleague, Ms. Gubernick, will come before you and ask for the only just verdict in today's case. Timothy Ray is not guilty by reason of insanity. Thank you.
Thank you, Mr. Carlson. Before the state calls its first witness, I will ask that everyone switch to gallery view. That button is in the upper right of your screen, and this will allow you to see both the attorneys and the witnesses at the same time.
May I proceed, Your Honor?
Give me just one moment.
Yes, Your Honor.
Mr. Soloway, call your first witness.
Yes, Your Honor. The state calls Detective Blake Booth to the stand. Now, Detective Booth, you and I have gotten to know each other over the course of this case, but if you could please introduce yourself to the jury and spell your last name for the record.
Hi, my name's Blake Booth. Booth is spelled B-O-O-T-H. I'm a detective for the Skelton Police Department.
Detective, how long have you been a police officer?
I've been with the SPD for about 23 years now.
And Detective, how much of that have you spent as a detective?
The last 15 years.
Now, Detective, I'd like to draw your attention to page 107 of your evidence packet. That's Exhibit 30. And please let me know when you've gotten there.
I can see Exhibit 30.
What is Exhibit 30?
This is a photo of Timothy Ray taken after we arrested him for Nathan's murder.
Is that a fair and accurate representation of Timothy Ray?
It is.
Your Honor, permission to, the state moves to enter Exhibit 30 into evidence.
No objection, Your Honor.
Exhibit 30 will be received.
Permission to show Exhibit 30 to the jury?
No objection, or you will be allowed, granted.
While we're waiting for co-counsel to share that exhibit, Detective, what is your involvement in this case?
So I'm the lead detective on the missing persons report of Nathan Ray and subsequent murder investigation. Throughout my investigation, I also conducted an interview with the defendant, Timothy Ray, where he confessed to killing his son. And as a result of that, we also searched the defendant's home and his cell phone.
Detective, Is the person shown in Exhibit 30 the person who admitted to killing his son, Nathan?
Yes.
Where did he tell you that he was when he killed Nathan?
He said it occurred at his home, which was 84 Conway Drive right here in Skelton County.
And what date did he tell you he killed Nathan?
October 17th, 2018.
We can go ahead and take down Exhibit 30. Detective, I want to get into the confession and that interview that you conducted. But before we get into the substance of it, what was the defendant's demeanor? How did he seem during that interview?
Well, he started crying as he talked about how he killed his son. He made some eye contact with me, but looked at the floor the most of the time. And he also seemed to answer my questions coherently.
Detective, let's turn now to the substance of that interview. What did he tell you led up to the killing of his son?
He said that Nathan had spilled some juice on his work laptop, and when he tried to dry it off and power it on, it was completely fried, so he started yelling at Nathan.
How did Nathan respond to being yelled at by his father?
Nathan started crying and ran to his room.
What did the defendant do after Nathan ran away from him?
He followed him in the bedroom and made him do all these sorts of exercises like jumping jacks.
How did Nathan respond to being told to do jumping jacks?
Well, he started to do the exercises, but after a while, he stopped and started crying and saying he wanted his mom.
How did the defendant react when Nathan started crying and saying he wanted his mom?
He went to his bedroom and he grabbed a belt, returned to Nathan's room, and started smacking him with it.
How did Nathan react to being smacked with that belt?
The defendant told me he started crying more hysterically, and apparently Nathan said that he hated his dad and just wanted his mom.
How did the defendant react this time to Nathan saying he wanted his mom?
He wrapped the belt around Nathan's neck and pulled really tight.
At any point in the interview, did the defendant say that Nathan died right away as soon as the belt was around his neck?
The defendant told me in our interview that he pulled until Nathan stopped screaming, until he stopped moving.
Detective, I want to draw your attention to Exhibit 29 on page 106 of your evidence packet.
I can see Exhibit 29.
What is Exhibit 29?
This is a photo of Nathan that his mother gave to me when she filed her missing persons report.
Is that a fair and accurate representation of Nathan Ray when he was alive?
Yes.
Your Honor, the state moves to enter Exhibit 29 into evidence.
Any objection from the defense?
Other than the 403 objection mentioned pre-trial, Your Honor, no.
I'm going to maintain my ruling that this is not substantially more prejudicial than probative, so overrule your objection on that basis. So this will be admitted onto the record.
Yes, Your Honor.
Your Honor, permission to show this exhibit to the jury via screen sharing?
Granted.
Detective, what did the defendant do with Nathan after he stopped moving?
Said he threw his body in a trash bag and buried Nathan in Brandywine State Park.
Did you ever find Nathan's body?
Yes, so after hearing that, we conducted a search of Brandywine State Park and pretty quickly found a trash bag.
Okay. We can pull down Exhibit 29, and I'd like to draw your attention, Detective, to Exhibit 19 on page 96 of that evidence packet.
I can see Exhibit 19.
What is Exhibit 19?
This is the trash bag we found at Brandywine State Park.
Is that a fair and accurate representation of the trash bag you found at Brandywine State Park?
It is.
Your Honor, the state moves to enter Exhibit 19 into evidence.
No objections, Your Honor.
Will be admitted.
Permission to show Exhibit 19 to the jury?
Granted.
Detective, are you aware of the cause of death of Nathan Ray?
Yes, I reviewed our autopsy report performed by the coroner, which concluded that Nathan died of asphyxiation.
We can pull down Exhibit 19. Detective, I want to turn now to another search that you conducted in this case. You mentioned before that you searched the defendant's cell phone. What did you find when you searched his cell phone?
We found some searches that were relevant to our murder investigation.
I'd like to draw your attention to Exhibit 10 on page 57 of your evidence packet.
I'm here.
What is Exhibit 10?
These are screenshots that we took of the defendant's phone.
How could you tell that that was the defendant's phone?
Well, as in one of the screenshots, Timothy Ray's name popped up, and we found the phone in the defendant's home and didn't find any evidence to suggest that it belonged to anyone else.
Is that a fair and accurate representation of the searches you found on the defendant's phone?
Yes.
Your Honor, the state moves to enter Exhibit 10 into evidence.
No objections, Your Honor.
It will be received into evidence.
Detective, what did the defendant search for?
He searched for three things. First, will bleach destroy a body? Second, countries that don't extradite for murder. And third, the search was, give me one moment.
Detective, would it help you to see that exhibit again?
It would, thank you.
Your Honor, permission to show this exhibit to the jury?
Granted.
And the third is how to get rid of a body.
I want to draw your attention to the date on that exhibit. What is October 18th in relation to the date that Nathan Ray died?
October 18th was the day after Mr. Ray said he killed his son.
Detective, what does extradite mean?
So if a country wouldn't extradite for murder, it means if there was a criminal prosecution for murder in the United States, the country would not deport that person back to the US for that proceeding.
No further questions.
Mr. Carlson, do you have any cross-examination of this witness?
Yes, Your Honor.
Whenever you're ready, counsel.
Detective, you're aware that the jury has to decide whether or not Mr. Ray was mentally ill at the time of his son's death.
Yes.
But you're responsible for not preserving the audio and videotape of his interrogation, is that right?
I didn't record or preserve the audio or video, no.
Now, that audio and video would have had the sound of Mr. Ray's voice.
The audio would have, yes.
It would have showed what he looked like the night of his interrogation.
Yes.
But because you didn't preserve a copy of that audio and video, the jury cannot see or hear Mr. Ray the night of his interrogation.
No, you can only gauge his tone through the transcript recording.
Exactly. Besides, for the transcript, we have to rely on your memory, correct?
That's right.
But your memory can't be trusted, can it, Detective?
I've been a detective for 23 years. I think my memory is as good as any.
Well, let's talk a bit about your memory. You testified in a preliminary hearing in this case, is that right?
I did.
That was the first hearing for this trial, is that correct?
I'm not aware. I'm not a lawyer, but it's the first time I had testified under oath.
It was in front of a judge.
Yes.
You were under oath to tell the truth.
Of course.
And it was only 2 months after that interrogation with Mr. Ray. Is that correct?
That sounds about right.
And when you were asked if Mr. Ray ever accused you of being in the CIA, you responded, no, he never said anything like that. Is that correct?
If I remember correctly, the question at the time was talking about the sobriety checkpoint. And at that time, when I was speaking to Mr. Ray at the sobriety checkpoint, he had never asked me if I was in the CIA.
Well, hang on just a moment, Detective. Just answering my question. You did say, in response to if you were asked if you were in the CIA, no, he never said anything like that. Is that correct?
Yeah, at the sobriety checkpoint, that's right.
Well, you were later asked about the interrogation as well. And when asked about that, you said, nothing the defendant said was odd. It was a normal interview. That's what you said, correct?
He was coherently responding to my question, so it wasn't odd to me, no.
But just responding to my question, your own words were, nothing the defendant said was odd. It was a normal interview. Is that correct?
That's what I just said. No, nothing seemed odd to me.
Mr. Ray accused you of being in the CIA, didn't he?
He asked me a couple times, yes.
Well, not just once, but at least 3 times. Is that correct?
If my memory serves me right, it was at the beginning when after I had handed him the waiver of rights form, and then after he had signed it during the course of the interview.
Detective, back to my question, though. It was at least 3 times that he asked you if you were in the CIA. Is that correct?
I only remember the 2 times right now.
Well, I say at least because the first time he asked you about the CIA was before the transcript was recording. Is that correct?
That sounds about right.
Detective, I'd like you to turn to Exhibit 3. It starts on page 40 of your electronic file. Let me know when you're there.
I can see Exhibit 3.
Detective, this is the word-for-word transcript. Is that of your interrogation with Mr. Ray? Is that correct?
Yeah, for questions and answers, yes.
Your Honor, I move to admit Exhibit 3 into evidence.
Mr. Soloway, any objection?
Yes, Your Honor. We do have objections to certain specific portions of this transcript. Specifically, we'd like to draw Your Honor's attentions to lines 6 and 9 and 23.
Before you get into details, Mr. Soloway, let's go outside the presence of the jury constructively.
Yes, Your Honor.
Okay. Which portions of the transcript are you objecting to?
Yes, Your Honor. We're objecting to lines 6, 9, and 23 on page 42, along with line 11 on page 44 of the evidence packet. Specifically, on line 6, 9, 23 of page 42 and line 11 of page 44, the defendant references things like, they told me to, things along those nature. It sort of varies from point to point what exactly he was saying. The reason that we object to those are inadmissible as hearsay. We have a good faith belief that the defense will be using this information to show the truth of the matter asserted, that the defendant in fact heard voices on October 17th. Your Honor, this is inadmissible hearsay.
Mr. Carlson, do you have a response?
Yes, Your Honor. To begin, the prosecution brought in this testimony, Exhibit 3, extensively on direct examination, so it comes in under 106 under rule of completeness for context. In regards to the hearsay statement, as for the truth of the matter of whether Mr. Ray was hearing voices, we're not arguing that he was actually auditorily hearing voices. They are by nature a hallucination. And if the hearsay objection is to themselves as to what the voices are saying, there is no declarant. So they're not hearsay.
Your Honor, if I may respond?
Certainly, Mr. Soloway.
I just want to clarify that our objection is to the defendant's statements, not to what any of the voices say, but rather to the fact that he did in fact hear voices. If the defense does not intend to use them to show that he actually heard voices, then we can address that. But it sounds to me like that's exactly how they intend to use those statements.
Mr. Carlson.
Your Honor, that's not the truth. Sorry, that's not an assertion of truth. Mr. Ray saying they told me to do it. We're not asserting that there is a they that told them, right? It just goes to show that he was hearing voices. It's not an assertion of truth.
The assertion, Your Honor, is that he was hearing voices. He is asserting that he was hearing voices in those statements.
Okay, I'm going to sustain the objection just to those limited lines as pointed out to Mr. Soloway, but other than that, I will allow the exhibit to be admitted onto the record with the redactions to the lines on page 42 as well as 43.
Excuse me, Your Honor, I apologize. A quick correction. That second set of lines is actually on page 44. I just want to be very clear for the record.
I understand, Mr. Soloway. The record is clear.
So I apologize, Your Honor. Can you just repeat the lines so I can mark them to make sure I obey the court's ruling?
Mr. Soloway, would you mind articulating the lines again?
Yes, Your Honor. It's lines 6, 9, and 23 on page 42. Just the specific portions where he talks about what they told him and what the voices were saying. And then also line 11 on page 44.
Yes, Your Honor. Thank you.
You can proceed, Mr. Carlson, whenever you're ready again.
Thank you, Your Honor. Permission to publish a demonstrative. These have been cleared with opposing counsel pretrial.
Granted.
Your Honor, outside the presence of the jury, I'd just like to be clear that in this demonstrative, when we reviewed it pre-trial, one of the lines that has since been redacted was in that demonstrative. And we just want to make sure that Your Honor's ruling is obeyed.
Constructively, the line has been redacted in the demonstrative, so I will still allow Mr. Carlson to display it.
Yes, Your Honor.
Detective, in the interrogation transcript on page 41, lines 22 to 23, when Mr. Ray accuses you of being in the CIA, your response is, Mr. Ray, we've been over this. You asked me the same thing earlier, remember? When I gave you that waiver of rights form, you asked me if I was from the CIA. Those are your words, correct?
That's what I said earlier, yes.
Thank you, Ms. Mauer. There's no recording of that conversation, is there?
No.
There's no recording of when you got Mr. Ray to sign the Miranda form.
We don't record our interactions before an official interview, no.
So just answering my question, there is no recording of when Mr. Ray signed the Miranda form, correct?
No.
For that interaction, we again only have your memory.
That's right.
When Mr. Ray mentioned the CIA, you didn't get a medic.
No.
You didn't consult a mental health professional.
I did not.
You just kept interrogating him.
He was confessing to the murder. I wanted to be sure that we had as many details as possible so that we can try to find Nathan's body.
Detective Booth, once more, answering my question, you just kept interrogating him. Yes or no?
I was listening to his confession.
At 2:17 in the morning.
Yes.
At this time, Mr. Ray was visibly upset, correct?
Yes.
And he was talking about this idea of his wife tricking him. Is that correct?
That's right.
And you played into this idea. Your Honor, permission to republish a portion of the transcript?
Granted.
On page 44, lines 3 to 6, you said, she had him tricked too good if he was saying that. She sounds like a piece of work. How do you make him understand that she couldn't trick him like that? I read that properly, correct?
You did.
And you also said, I bet you screamed it at him because he needed to understand.
That's what it says.
Mr. Ray's behavior the night of his interrogation wasn't the only time you were alerted to potential mental health issues. That's correct?
I don't believe so. No.
Well, let's just back up a moment. Jessica Ray, Nathan's mother, shared with you her concerns about Mr. Ray's mental health. Is that right?
I remember her loosely saying that she thought he was acting strange. She never mentioned any disorder that Mr. Ray was diagnosed with.
Well, just a moment, Detective. You called Jessica Ray to inform her that you found her son's body. Is that right?
I did.
And when you called her, she was devastated.
She was asking me for details. I don't know if I would say she was devastated, but I mean, I assume anybody would be, upon finding that their child was dead.
She was sobbing uncontrollably?
That sounds about right, yes.
She told you, I knew I should have never left Nathan alone with him when he was acting strange.
Objection, hearsay.
Your Honor, to begin, the witness actually already included this statement in one of his responses to me, but in response to the hearsay objection, it is an exception because it is an excited utterance.
Overruled.
Detective Booth, she told you, I knew I should have never left Nathan alone with him when he was acting strange. Is that correct?
That's what she said.
She told you, I knew he was going crazy.
Yes.
I want to bring you back to the night of the interrogation. Your Honor, permission to republish portions of Exhibit 3.
Granted.
Mr. Ray told you, "I didn't mean for any of this to happen. I didn't mean to kill him." Correct?
Yeah, that's what he stated.
And he said, "I didn't know what was happening."
That's a portion of what he said, yes. He also
Thank you.
said, as you'll see there, "I didn't mean to." You have to understand, I didn't mean to.
Exactly. He said, "I didn't know what was happening." Is that correct?
As I already said, yes.
Thank you. Nothing further, Your Honor.
Thank you, Mr. Carlson. Mr. Soloway, do you have any redirect of this witness before we dismiss him?
Yes, Your Honor. Detective, why did you not preserve the video and audio recordings of your interview with the defendant?
It wasn't necessary. This is an open and shut case. Mr. Ray
Objection, Your Honor.
identified in...
Improper characterization as to an open and shut case, and I move to strike.
Mr. Soloway, do you have a response?
Your Honor, the defense attacked this witness for failing to preserve this evidence. Your Honor, this is just the witness's subjective point of view as to why he did not specifically preserve this evidence.
Overruled.
Detective Booth, I'll ask the question again. Why did you not preserve the audio and video recording of your interview with the defendant?
It wasn't necessary. This was an open and shut case. Mr. Ray identified in detail how he killed his son and what he did with his body. The audio or video of that interview wasn't going to change any of that.
No further questions.
Thank you, Mr. Soloway. Detective Booth, you'll be dismissed.
Thank you, Your Honor.
Do the people have any other evidence they'd like to present at this time?
Yes, Your Honor. The people call Dr. LaGreca to the stand.
Thank you, Ms. Chandler.
Can you see and hear me okay?
Yes.
Dr. LaGreca, can you please introduce yourself to the members of the jury?
My name is Dr. LaGreca. Last name is spelled L-A-G-R-E-C-A.
Now, Dr. LaGreca, what is your connection to this case?
I was hired to evaluate the insanity charge of Mr. Ray.
Now, before we get into that evaluation, I want the jury to know about your background. What kind of doctor are you?
I'm a forensic psychiatrist.
What is forensic psychiatry?
Forensic psychiatry is a subsection of psychiatry that deals directly with the legal system.
Now, what education did you obtain to be able to be a forensic psychiatrist?
Yeah, for undergrad, I completed my bachelor's in chemistry at the University of Delaware, after which I attended UPenn for medical school. After that, completed my residency in psychiatry at UCLA, and finally, I was board certified in forensic psychiatry back at UPenn.
What about expert testimony?
I've served in approximately 7 prior testimonies, 3 of which were directly related to schizophrenia.
Now, I want to shift to talking about this case. Without stating it, were you able to come to a conclusion?
Yes, I was.
What all did you review in coming to your conclusion?
In order to review this case, I reviewed all of the exhibits presented within the case. I also reviewed the patient interviews and other family member interviews. I also reviewed Dr. Riley's clinical interview.
Was that information sufficient to form your conclusion?
Yes, it was.
Did you use reliable principles and methods that are common in your field?
Yes, I did.
And did you apply those reliable principles and methods to the facts of this case?
Yes, I did.
Your Honor, at this time, the state moves to tender Dr. LaGreca as an expert in the field of forensic psychiatry.
Defense, do you have any objection to the tender?
No objection to that tender, Your Honor.
Okay, the witness will be received by the court as an expert witness. Ms. Chandler, you can continue your examination.
Dr. LaGreca, we have heard that there is a plea in this case of not guilty and not guilty by reason of insanity. Are you familiar with the definition of legal insanity?
Yes, I am.
And did you determine in this case whether Mr. Ray had a severe mental disease or defect?
I did evaluate Mr. Ray, and no, I did not.
And why did you go about doing that?
I evaluated Mr. Ray to see whether he was experiencing a severe mental illness, because that is the first prong of evaluating legal insanity.
Now, are you aware of whether the defense is claiming Mr. Ray had any severe mental disease?
Yes, I believe the defense is claiming that Mr. Ray suffered from severe schizophrenia, although I do disagree.
Are you familiar with schizophrenia?
Yes, I am. I've treated multiple patients in the past who suffered from schizophrenia.
Now, generally speaking, can an individual with schizophrenia remain law-abiding?
Yes, they can.
And generally speaking, could an individual with schizophrenia know right from wrong?
Yes, they can.
Now, did you determine in this case whether Mr. Ray had schizophrenia?
In this case, I determined that Mr. Ray does not fit the DSM-5 criteria for schizophrenia. Rather, I believe that he fits the DSM-5 criteria for malingering.
Now, you mentioned the DSM-5. What is that?
The DSM-5 is a diagnostic standard manual, and we use it in psychiatry, and it lays out the criteria for numerous psychological diseases, including schizophrenia and malingering.
What is the criteria for schizophrenia in the DSM-5?
Yeah, to be diagnosed with schizophrenia, you have to have 2 or more of the following symptoms. 1, hallucinations. 2, delusions. 3, grossly disorganized speech. 4, grossly disorganized or catatonic behavior. And finally, negative symptoms.
Now, you said you reviewed Dr. Riley's report in this case. Are you aware of whether he found Mr. Ray had schizophrenia?
Yes, Dr. Riley did find that Mr. Ray suffered from schizophrenia, although I do disagree.
Do you recall what symptoms he said Mr. Ray exhibited?
Dr. Riley mentioned that Mr. Ray suffered from delusions, hallucinations, and negative symptoms.
What about the other 2?
We both disagree that Mr. Ray suffers from the other 2.
Okay, I want to go through the 3 symptoms with you that you just testified to. Your Honor, permission to share screen with a demonstrative listing the 3 symptoms that the witness just testified to, which has been approved by opposing counsel prior to trial.
Granted.
Starting with delusions, what are those?
Delusions are beliefs that are not based on reality.
Did Mr. Ray have delusions?
Mr. Ray described paranoia regarding his wife's affair, but unfortunately, this was in fact based on reality. And additionally, prior to the 2017-2018 timeframe where his wife was in fact having an affair, he was described as a normal family-oriented individual. So no, I don't believe that this fits in the criteria for delusions.
Hallucinations, what are those?
Hallucinations are sensory perceptions that lack any sort of real elicitation.
In your expert opinion, did Mr. Ray have hallucinations?
Mr. Ray mentioned that he suffered from hallucinations since age of 10, but unfortunately, numerous family interviews and clinical interviews didn't indicate any evidence of such. Additionally, he described hallucinations as voices that were telling him his wife was having an affair. But unfortunately, this is more consistent with anxious thoughts as it was actually based in reality. So no, I don't believe that he was suffering from hallucinations.
Negative symptoms, what are those?
Negative symptoms refer to the inability to do something, and this can cause profoundly negative impacts on one's life.
Now, we heard descriptions that Mr. Ray may have been lacking self-care. Is that a negative symptom?
It certainly could be if it was pervasive enough, but unfortunately, in the case of Mr. Ray, he He was described to be a high-functioning individual, both at work and at home, and thus I don't believe this fits in the criteria of negative symptoms.
Thank you. We can go ahead and take that demonstrative down. Taking all of those symptoms into consideration, what was your opinion of Mr. Ray?
My medical opinion of Mr. Ray is that I don't believe that he fits the criteria laid out in the DSM-5 for schizophrenia. In fact, I believe that he does fit the criteria for malingering.
Okay, Dr. LaGreca, I want to shift now to talking about malingering. What is that?
Malingering is the simulation of a disease. Usually it's to attain an external incentive.
How do you go about determining whether one is malingering?
The DSM-5 clearly lays out the factors required to diagnose or to consider malingering.
What are those factors?
Yeah, so it lays out 4, and it mentions that any combination of the following would strongly consider. 1, if the case is within a medical legal context. Number 2, if the patient reports are grossly inconsistent with objective findings. Number 3, if the patient is uncooperative during clinical interviews. And finally, if the patient is diagnosed with antisocial personality disorder.
Which one of those did you find applied to Mr. Ray?
I believe all of them applied except for the diagnosis of antisocial personality disorder.
Okay, I want to go through those factors with you. You mentioned medico-legal context. What is that?
Medical legal context is when the diagnostic evaluation, the psychological diagnosis has profoundly drastic impacts on the legal status of an individual.
And that factor in relation to Mr. Ray?
It certainly applies to Mr. Ray. In fact, most of the symptoms that he elicited and described were described after the criminal case.
You also mentioned subjective versus objective findings. What is that?
Subjective versus objective findings refers to when a patient describes feeling symptoms, but there are no data, the data that's collected is inconsistent with what they're describing. In this case, with Mr. Ray described experiencing hallucinations since he was the age of 10. But unfortunately, since then, there were multiple family interviews and clinical interviews that all denied such symptoms.
You also mentioned lack of cooperation in a clinical interview. Did Mr. Ray exhibit that?
He did. Actually, in his interview with Dr. Riley, when Dr. Riley brought up the context of his laptop, whether it was personal or for work, Mr. Ray actually expressed temper and was uncooperative during that interview.
Now, Dr. LaGreca, taking all those factors into consideration, what was your professional opinion of Mr. Ray?
My opinion of Mr. Ray is that he does not fit the DSM-5 criteria for schizophrenia. In fact, I believe he should be strongly considered and will be diagnosed with malingering.
No further questions, Your Honor.
Thank you, Ms. Chandler. Ms. Gubernick, do you have any cross-examination of this witness?
Yes, Your Honor. May I proceed?
Whenever you're ready, counsel.
Doctor, you'd agree that if you make incorrect assumptions, your opinion could be flawed. Isn't that true?
Certainly.
People with severe mental illnesses often grow up experiencing childhood trauma.
It's one of the associated factors.
But you assumed that Mr. Ray's childhood trauma was not significant.
Yes, I believe so, yes.
Even though his mother abused him.
I think this was based off of an interview with his dad. Yes.
She bathed him in freezing water.
Objection, Your Honor, hearsay.
Ms. Gubernick, do you have a response?
Yes, Your Honor. Under Federal Rule of Evidence 705, this witness has already stated that this is evidence that they relied on in reaching their expert opinion. Hearsay evidence is admissible then to undercut their opinion.
May I respond, Your Honor?
You may.
Although it may be admissible under Rule 705, we still have to consider Rule 403. This evidence in eliciting the contents of these statements is extremely prejudicial in this case because we do not have a chance to cross-examine Mr. Ray's father who made these statements, and we don't have a chance to ask him about the context of these statements or break down whether these statements were actually credible, and thus they should not be allowed, or the defense should not be allowed to elicit these statements.
Your Honor,
Overruled.
I'm sorry.
I overrule the objection. You can continue, Ms. Gubernick.
She bathed him in freezing water. Is that a yes, doctor?
Yes, I guess.
She often refused to feed him.
Yes.
You also assumed that Mr. Ray's family history does not support a diagnosis of schizophrenia.
Yes, I do.
You know that a family history of severe mental illnesses makes someone more likely to develop a severe mental illness, like schizophrenia.
I believe it does. Genetics does play a role in association, not causation, but yes.
Mr. Ray's mother suffered from severe mood swings,
Yes.
severe enough that she was committed to an institution.
Yes, she was.
And doctor, you'd agree that anxiety disorders experienced as a young man can worsen and eventually become a severe mental disorder like schizophrenia.
Comorbid psychological issues are associated with other psychological issues, yes.
But you assume that that wasn't the case here.
I don't believe so, no.
Mr. Ray has a documented history of anxiety and depression.
He has a documented history of anxiety. He does have symptoms of depression.
Anxiety and depression severe enough to cause him to be medically discharged from his service in the military.
Yes.
Now, doctor, if you ignore facts such as the timing of when certain events happened, your opinion could be incorrect. Isn't that true?
Yes, they could.
You told these jurors on direct examination that Mr. Ray was not having delusions because his wife ultimately did have an affair.
Yes.
But doctor, that affair started in 2018, right?
Yes.
You didn't tell the jury that Mr. Ray reported hearing voices telling him that his wife was, quote, screwing around on him all the way back in 2015, did you?
No.
And in that same year, Mr. Ray feared that his wife and son would, quote, cut him up with a knife and leave him.
Yes, that was said.
You didn't mention any of that on direct examination.
No, I believe his delusions, for the most part, were in fact later proven to be true. I'm not really sure when infidelity may have occurred. Maybe it occurred earlier or later. But to me, considering his delusions were later proven to be true, they were more likely anxious thoughts and delusion, not delusions.
Doctor, returning to my question, you didn't mention any of these quotes from Mr. Ray from 2015 on direct examination, did you?
No, I did not.
In fact, not only did you not testify about these words, you wrote a report in this case, correct?
Yes, I did.
Please turn to page 69 of your electronic notebook to Exhibit 13. Let me know when you're there.
Yes, I am there.
This is your 7-page report, right?
Yes, it is.
You provided this report to prosecutors knowing that it could be used in this trial.
Yes, I did.
And nowhere in that report do you mention the fact that Mr. Ray was paranoid about the affair as early as 2015.
No, I did not.
You also ignored Dr. G. Giuseppe's sworn testimony about Mr. Ray.
I do believe I did include Dr. Giuseppe's clinical interviews and clinical diagnosis within my report.
Well, let's talk about what you didn't include. Dr. G. Giuseppe evaluated Mr. Ray in 2017, before Jessica Ray had an affair.
Okay.
You agree, right, doctor? That's true?
Yes. Yes, it's true.
During that 2017 appointment, she pointed out that Mr. Ray looked terrible.
Yes, she had mentioned that.
He looked like he hadn't showered in weeks.
Yes, she did mention that.
He accused his doctor of listening in on his phone calls.
Yeah, I believe so.
He accused his doctor of siding with his wife and conspiring against him.
Yes, Dr. Di Giuseppe had mentioned that.
Now, Dr. G. Giuseppe refers patients to mental health professionals when she believes that their symptoms are serious.
Yes.
Based on his symptoms, Dr. G. Giuseppe referred Mr. Ray to a psychiatrist.
Yes, she did.
She wanted him to be seen the very next day.
Okay.
That's true, right, doctor?
Yes.
You didn't mention that Dr. G. Giuseppe wanted him seen by a psychiatrist on direct examination, did you?
No, I did not mention that.
And we can agree it's not in your report either.
No, that aspect was not in the report.
By the way, doctor, you wrote that report based on 100 pages of documents that you reviewed.
Yes, I did.
It took you 25 hours.
Yes.
And in those 25 hours that it took you to review 100 pages, you billed $12,500. Isn't that true?
Yes.
You also know that Mr. Ray said on numerous occasions that he believed that government agents and the CIA were watching him.
I believe he mentioned that after his criminal, after he was met in the toll booth.
Right, he said it to Detective Booth.
In the medical legal context, yes, he did.
Said it to Officer Wentz.
Yes, after he committed the murder, he did mention all that.
Said it to Dr. Riley as well.
Yes, he did. All of which after he committed the crime.
But we can agree, never mentioned on direct examination nor in your report, right, doctor?
Can you repeat that, please?
You didn't mention his concerns about the CIA or government agents watching him on direct examination or in your report.
I actually did elicit this information indirectly. I had mentioned that he did claim these symptoms after he was conducted his crime.
Not in your report, right, doctor?
Not explicitly, no.
Doctor, you also ignored the words of Jessica Ray, Nathan's own mother in this case, didn't you?
In what regard?
Well, doctor, they're not in your report.
Okay.
You didn't talk about them on direct examination.
No, I did not explicitly mention her, no.
Because the reality is, Mr. Ray had mood swings all throughout their relationship.
She did mention that she had mood swings, but I believe this was closer. These symptoms were closer to when they found out she was having an affair. So I believe it's more likely to be due to the situation of their relationship.
Doctor, regardless of your characterization, Jessica Ray said that Mr. Ray was having mood swings all throughout their relationship. Isn't that true?
While it's true, I do believe it's localized to their relationship. I believe that his boss at Computerland didn't mention any such behavior at work.
Doctor, I'm going to direct you back to my question. We're not talking about his boss. Jessica Ray, his ex-wife, said that Mr. Ray was having mood swings throughout their relationship. Isn't that true?
Yes, she did.
He would lock himself in the bathroom for hours.
Yes, she did mention that.
Wouldn't shower for more than a week at a time.
Yes, she did mention that.
As soon as she heard that her son was killed, she told police, quote, "I knew I should have never left Nathan alone with him when he was acting strange."
Yes, she did mention that.
And you never mentioned her words, doctor, quote, "I knew he was going crazy."
No, I didn't explicitly mention that, no.
You didn't mention it at all, did you, doctor?
I didn't explicitly mention that, no.
No further questions.
Thank you, Ms. Gubernick. Ms. Chandler, do you have any redirect based on that?
Briefly, Your Honor.
Whenever you're ready, counsel.
Thank you. Dr. LaGreca, are mood swings on their own indicative of schizophrenia?
No, not at all.
And Mr. Ray's mom, was she ever diagnosed with schizophrenia?
No, she was never diagnosed with any particular mental disorder.
No further questions, Your Honor.
Thank you, Ms. Chandler.
May this witness be excused?
Dr. LaGreca will be excused. Thank you for your testimony here today, sir. Chandler, does the state have any additional evidence they'd like to present at this time?
No, Your Honor. The state rests.
Thank you. Ms. Gubernick, does the defense have any motions they'd like to bring, or shall we proceed into your case in chief if you choose to present one?
Your Honor, we do not have a motion at this time. We do ask if we could just have a brief recess before moving into the case in chief, if that's okay.
How about we take 5 minutes? Ms. Chandler, work for you?
Yes, Your Honor, that's great.
5 minutes. Court will be in recess.
Your Honor.
Your Honor, may we request a time check when we come back from the break?
Certainly. We'll address time when we come back from break. Okay, and I understand there's a stipulation regarding the time remaining for the each party. Is that correct? Looks like 24 minutes, 50 seconds remaining for the state, 30 minutes, 22 seconds remaining for the defense. Do I understand that correctly?
Yes, Your Honor, that seems right. Our timekeeper agrees with those.
Okay. And do we have all our jurors back as well?
I'm back, yes.
Thank you, Mr. Benjamin. Juror Quinn and Juror Valaria, are you with us? We'll just give them a moment.
Yeah, I'm here.
Thank you, Juror Valaria.
Sorry, did I look dormant? I've been here the whole time.
No. Just coming back from a break. I want to make sure you're still with us and we didn't lose you in transition somewhere.
No, we're here. Thank you.
Mr. Quinn, are you with us as well?
Yes, I am. Been here.
Excellent. Defense, do you have any evidence you'd like to present in your case in chief?
Yes, Your Honor. The defense calls Dr. Riley.
Okay.
Permission to proceed, Your Honor.
Whenever you're ready, Mr. Carlson.
What do you do for a living, Dr. Riley?
I own my own military forensic psychiatry practice, providing psychiatry services to veterans who are patients in legal matters.
In June of 2019, I asked you to conduct an independent analysis to tell if Mr. Ray was seriously mentally ill on the day his son died. Did you reach a conclusion?
Yes.
How long have you been a psychiatrist?
I've been a psychiatrist for 22 years.
And besides for medical school, what other specialized trainings have you completed?
I did most my residency and a one-year fellowship in forensic psychiatry at the Walter Reed Medical Center.
Did you practice psychiatry in the military?
I did. I served as a psychiatrist while deployed in Iraq. Later, I was on a clinical assignment at Walter Reed, managing the psychiatric inpatient unit. There, I treated hundreds of military personnel suffering from mental illnesses, including schizophrenia.
Doctor, what does it mean to be board certified?
It's an acknowledgement of an individual's competence in the field of medicine.
And are you board certified?
I am.
Have you published articles about the treatment of mental illnesses, specifically schizophrenia?
Yes, I have. I believe it's 15 peer-reviewed articles, a majority of which were about forensic psychiatry, and 2 specifically regarding schizophrenia.
Your Honor, I offer Dr. Riley as an expert in the field of forensic psychiatry.
Mr. Soloway, do you have an objection to the tender of the good doctor here?
No objection, Your Honor.
The doctor will be received by the court as an expert witness. Mr. Carlson, you can continue with your examination.
Dr. Riley, at the time of his son's death, was Mr. Ray suffering from a severe mental illness?
Yes, Mr. Ray suffers from severe schizophrenia, as well as anxiety and depression.
And what happens when someone has all of those conditions at once?
The anxiety and depression can exacerbate the symptoms of schizophrenia.
Are those findings and the ones you will share with the jury today ones that you reached with a reasonable degree of medical and psychiatric certainty?
Yes.
Now, the jury has heard that you first met Mr. Ray in the military. How did you end up seeing him?
Yes, that's correct. I treated him in 2010. His commanding officer reported that Mr. Ray had been seeing things, was sleepwalking, and said that he had reported feelings of depression and he wished he were dead.
How did Mr. Ray describe his symptoms back in 2010?
He confirmed he was feeling depressed. He had trouble sleeping and felt worried and anxious.
What was your diagnosis based on what you knew then?
At the time, it was general anxiety disorder.
Now, even without Mr. Ray admitting hallucinations to you, could he remain in the military?
No, he was medically discharged based on the diagnosis.
And what, if anything, did you recommend he do once discharged?
Upon discharge, I recommended he continue to see a therapist and prescribed him Paxil.
Is there any record that he did take Paxil or did see a therapist?
No, there was none.
Doctor, I'd like to take you back to 2019. When I hired you, I provided you with all of the documents in this case, police reports, medical records, witness statements. Did you review all that information?
I did.
Did you speak with anyone from Mr. Ray's life?
Yes, I spoke to his father, his former boss, and his ex-wife, Jessica Ray.
And what about Mr. Ray?
I interviewed him for 3 hours.
What was he like in that interview?
For the most part, he was fine, although he did demonstrate some paranoia. He thought there was a camera in my microwave and kept accusing me of being some government agent that was out to get him.
Were there any other significant behaviors you noted?
Yes, we had to stop the interview several times, specifically 3 times, once because of his paranoia, and 2 other times because he started to cry hysterically.
What did Mr. Ray share with you about the day his son died?
He said that he was already feeling anxious about work that morning. His son then spilled juice on his laptop, amplifying his anxiety.
And how did Mr. Ray react?
He said the voices told him his son did it.
Objection, hearsay.
Response, Mr. Carlson.
Your Honor, this is an exception to hearsay, as it is statements for the purpose of a medical diagnosis. And in the event that the court doesn't find that that exception applies, it's still admissible under 703.
Mr. Soloway, you seem like you want to make a response.
Yes, Your Honor, if I may respond outside the presence of the jury.
Certainly.
Your Honor, 8034 does not apply to these statements. 8034 is specifically for the purpose, if statements are made for the purpose of medical diagnosis or treatment. That does not apply to all diagnosis, and it does not apply to all statements made to someone with a medical degree. The diagnosis conducted, or the evaluation conducted by Dr. Riley in this case was a forensic diagnosis, not a medical diagnosis. Forensic being specifically for the purposes of legal proceedings. This does not carry the same weight that was intended when 8034 was written. There's an assumption under 8034 that patients will be honest with their doctors because they're trying to receive treatment. That doesn't apply in a medical legal context when it's specifically a legal diagnosis. Therefore, 8034 does not apply as an exception to hearsay in regard to this. I can also respond to the 703, Your Honor.
Yeah, I understand your concern about the indicia of reliability for the hearsay objection. And leaving that aside for the moment, can you respond to the objection under Federal Rule of Evidence 703?
Yes, Your Honor. The standard, so while an expert may rely on otherwise inadmissible evidence to come to their conclusion under Rule 703, in order to actually admit otherwise inadmissible evidence, the probative value of that information must substantially outweigh any unfair prejudice. Your Honor, in this case, there is substantial unfair prejudice in terms of using hearsay and hearsay statements that we have no ability to cross-examine. It's very much self-serving hearsay, and because it's self-serving on the part of the defendant, it should be excluded as having a high prejudicial effect.
Mr. Carlson, can you make a response specifically to the state 703 position that this doesn't meet the standard for admissibility under that rule?
Yes, Your Honor. Dr. Riley has diagnosed Mr. Ray with schizophrenia, a medical diagnosis, and it is important that the jury understand how she reached that conclusion. Hearing the weight that Dr. Riley gives certain statements by the defendant directly goes to the jury's ability to understand her conclusions and her methodology. It goes to weight, not admissibility.
And I'm going to overrule the objection at this point. I believe we do want to hear what the doctor has to say on this issue. So, Mr. Carlson, I'm going to allow you to continue with your examination.
Yes, Your Honor.
Dr. Riley, I'm going to repeat the question to remind you where we are. How did Mr. Ray react to his son spilling juice on his laptop?
He said the voices told him his son did it on purpose to sabotage him. So as punishment, he forced him to do jumping jacks, high knees, run in place to essentially remove the evil from him.
And what did Mr. Ray say happened next?
He said his son wasn't listening. That made him mad. He said he went to his bedroom to calm down, but that didn't work. He then heard a creepy voice that told him he should kill his son for acting out. So Mr. Ray said he went back into Nathan's room and strangled him with a belt.
Now, the jury has already heard a bit about schizophrenia. Is it a common disorder?
No, less than 1% of the world's population suffers from it.
The jury has also heard that childhood trauma and genetics are often associated with schizophrenia. Was there childhood trauma?
Yes, that's correct. Mr. Ray's mother specifically would force him to take baths in cold water and often would refuse to feed him and eventually left him at age 3.
And in terms of genetics, was there any indication that mental health issues ran in his family?
Yes, so the mother is a direct parent. She was institutionalized with symptoms resembling schizophrenia when he was 6. Soon after that, when he was 10, Mr. Ray himself began to hear voices.
The jury has already heard a bit about the DSM-5. Can you specifically share with us what the criteria for the DSM-5 is for diagnosing schizophrenia?
Yes, to diagnose an individual needs 2 or more of the 5 DSM-5 symptoms for at least 1 month or longer, and that's the period of time that they need to exhibit symptoms. The second prong of that diagnosis is having 2 or more, In addition to having 2 or more of these symptoms, an individual also has to show impairment in one of the major areas of functioning. That includes work, interpersonal relations, and self-care for a significant period of time since the onset of disturbance. And finally, the disturbance cannot be caused by effects of a substance or another medical condition.
Doctor, did you use the DSM-5 in your diagnosis of Mr. Ray?
I did.
I'd like to start with the third criterion first. Was there any evidence Mr. Ray's behavior was a result of a substance or other medical condition?
No, Mr. Ray did not have any other medical history, nor was there evidence of him taking any substances.
Your Honor, permission to publish a demonstrative that has been shared with opposing counsel pre-trial.
Granted.
Doctor, I'm pulling up the 5 symptoms that are listed in the DSM-5 for schizophrenia. Which, if any of these, was Mr. Ray suffering from?
Specifically, Mr. Ray was suffering from delusions, hallucinations, and an inability to control emotions, also categorized under the negative symptoms.
So what showed Mr. Ray was suffering from delusions?
His paranoia. I witnessed a bit of it firsthand during my appointment. He said that the government was tracking him. Again, he accused of there being a camera in my microwave. He also expressed extreme paranoia to Officer Wentz when he was stopped at the sobriety check, saying the CIA was watching him.
Was he suffering from delusions before his arrest?
Was. Mr. Ray reported being paranoid in 2015. His wife and son were conspiring to cut him up with a knife and leave him.
What about hallucinations?
As for hallucinations, so hallucinations are when people see, hear, feel, or smell things that aren't there. Hearing voices is a form of auditory hallucinations. Mr. Ray was hearing voices starting when he was 10 years old. His superior officer reported that he had been seeing things in 2010. In 2015, he told me things got worse. He started hearing these male voices telling him his wife was cheating on him with their neighbor.
Did Mr. Ray experience any visual hallucinations?
He did. Mr. Ray indicated that he started having visual hallucinations, including triangles on the wall, which changed shapes and colors, as early as 2017.
And how did Mr. Ray show signs of negative symptoms?
Through his social phobia. For example, he would isolate himself in the bathroom. He also had some negative symptoms, include the impairment of managing emotions. In front of me, he had multiple crying outbursts during our interview.
Were you able to independently corroborate his symptoms with other people?
I was. I spoke with his boss, his father, and his ex-wife, who confirmed these symptoms. I also read his primary care's findings as well.
What did Mr. Ray's boss tell you?
His boss said Mr. Ray experienced emotional instability at work. One time, I believe Mr. Ray got into an altercation with another employee, of which Mr. Ray grabbed the employee by the shirt, slammed him against the wall, and said, "I'll kill you."
And how did his boss share any other behaviors with you?
Yes, actually, leading up to the arrest, Mr. Ray was also crying at his cubicle on 3 different occasions.
What did you learn from his physician that was significant?
His physician examined Mr. Ray on several occasions. Particularly in 2017, his symptoms were severe enough to cause his doctor to refer Mr. Ray to a psychiatrist.
And what did Mr. Ray's ex-wife share with you about their married life?
She stated that her ex-husband always had issues with mood swings and would feel okay one minute and next he couldn't stop crying. And towards the tail end of their marriage, Mr. Ray became more isolated over the years. Again, he would lock himself in the bathroom for hours at a time and refuse to come out. And she also told him she was filing for divorce a few days before Nathan's death.
Did she talk about his hygiene?
She did. Jessica shared with me that Mr. Ray would go over a week without showering.
What about in the months leading up to Nathan's death? How did Jessica Ray describe her husband at that time?
At that time, she told me that Mr. Ray had turned into a completely different person before she had her affair, and often pleaded with him to get help to go see a psychiatrist or something. Was all of this information sufficient for you to conclude that Mr. Ray suffered from schizophrenia? Yes, so the DSM-5 requires 2 out of the 5 symptoms to diagnose schizophrenia, of which Mr. Ray has at least 3, all for more than 1 month before his arrest. Thank you, Ms. Maurer. Doctor, the prosecution talked today about malingering. What is your opinion on malingering? There's always a possibility that a patient is malingering or making up their symptoms to create a legal defense. But so many independent sources confirmed symptoms before Nathan's death. His father, his boss, his commanding officer, and most notably, Mr. Ray's ex-wife, Nathan's own mother. Well, why were the ex-wife's comments most notable? Because of the timing. Remember, the diagnosis of schizophrenia depends on demonstrating symptoms for a certain particular time period. So this is a month or more. And Mr. Ray's ex-wife confirms these symptoms have been ongoing for more than a month, all before Nathan's death. Is there any treatment Mr. Ray has received since that corroborates your diagnoses? Yes. In prison, he was actually prescribed 300 milligrams of Seroquel. And doctor, for us that don't know medicine, what is Seroquel? Seroquel is an antipsychotic, and it's used to treat certain medical conditions and mood conditions. Specifically, these conditions can include schizophrenia, bipolar disorder, and sudden episodes of mania or depression associated with bipolar disorder. A prescription of Seroquel could be used to treat any of those that I mentioned. Doctor, is schizophrenia a mental condition that can affect the ability to know right from wrong? Yes, it can. Can it keep some people from understanding the nature and quality of their acts? Yes. During your interview, did Mr. Ray acknowledge that what he did was wrong? Never. I asked him if he thought killing his son was wrong, and he responded that he was in a better place now. I asked if he still would have done it if a police officer were watching, and he said yes. Thank you, doctor. Nothing further.
Thank you, Mr. Carlson. Mr. Soloway, am I correct to assume that you have some cross-examination of this witness?
Yes, Your Honor.
Whenever you're ready, Counselor.
Dr. Riley, I want to start with where you agree with Dr. LaGreca. Now, the two of you agree on the method for diagnosing schizophrenia.
Yes, the DSM-5 is a universal gold standard.
Right. The two of you agree that the DSM, that's a reliable authority.
That is a reliable authority.
You also agree that less than 1% of the population has schizophrenia.
Yes, that's correct.
Well, if there are billions of people in the world, that means that millions of people would have schizophrenia.
Yes, that's correct.
You and Dr. LaGreca also agree that having a mental disorder doesn't necessarily mean someone would commit crimes.
Yes, that's correct.
And you agree that having schizophrenia doesn't necessarily mean someone would be violent.
Not necessarily. It can actually cause impairment and cause possibly violent outbursts.
Okay, and you and Dr. LaGreca, you both agree that you relied, at least in part, on things that the defendant told you in coming to your diagnosis.
Yes, that's correct. And collateral information, which is key to diagnosing mental disorders.
But I'm going to bring you back to my question. You agree that, at least in part, you relied on statements that the defendant made.
For some, yes.
Okay, well, let's talk about some more important things about forensic diagnosis. Now, you'd agree that it's helpful to have a diagnosis from a treating physician before coming to a forensic diagnosis.
It would be helpful, yes.
There was no such diagnosis in this case?
There was no formal diagnosis. It can go unchecked for years, and that could lead to a worsened schizophrenic episode, which in this case, I think Mr. Ray had experienced.
But you would agree that a patient might have different motivations for talking to a treating physician versus a forensic psychiatrist.
He did not seek care in between, so we don't have that. He never had that.
I'm not talking about Mr. Ray, Dr. Riley. I'm talking about, in general, when a patient sees a treating physician, they may have different motivations from when they're speaking to a forensic psychiatrist.
Potentially.
They could potentially be attempting to escape prosecution for a crime.
Yes, I mean, if a patient wants to go to a medical doctor to get treated for something, yes.
You did not treat the defendant at your interview in 2019.
No, I did not.
But another doctor did treat the defendant after you conducted that interview.
I believe I diagnosed him in 2020, and he began treatment actually in 2018. Correct me if I'm wrong.
It's correct that you conducted your examination in September of 2019?
Yes, that's correct.
And the defendant saw a jail psychiatrist in November of 2019.
Oh, yes, sorry. Sorry if I had my dates wrong. I can double check that. But
Right. That's Dr. Nara Simhan, who prescribed him Seroquel.
yes.
Well, you mentioned that Seroquel has other uses, correct?
Yes, but it is definitely it's a drug we use with caution because of the side effects.
But it has uses other than treating schizophrenia.
Yes, but one of the primary uses for it is schizophrenia.
Well, despite the fact that one of the primary uses for it is schizophrenia, Dr. Nara Simhan did not diagnose the defendant with schizophrenia.
He did not.
And Dr. Nara Simhan, in his report, in fact, did not note any signs of delusions or hallucinations.
No, he did not.
So of the 3 doctors that evaluated the defendant after he killed his son, that's yourself, Dr. LaGreca, and Dr. Nara Simhan, of those 3, you're the only one who diagnosed him with schizophrenia.
I officially diagnosed him with schizophrenia, correct?
I want to bring you back to my question, which is, you are the only one of those 3 doctors who did diagnose him with schizophrenia.
Yes.
Okay, so given that there's disagreement in this diagnosis, I want to talk about whether or not you can trust the things that the defendant told you. Now, there's an increased chance of malingering when someone is accused of a crime.
There is, yes.
It's even higher when it's a serious crime.
Yes, that's correct.
And you would agree that murder, that's a very serious crime.
Yes.
Now, you also saw the defendant in 2010, correct?
I did.
And in 2010, he denied having hallucinations.
He denied, yes, that's correct. He did not report to me any hallucinations at the time.
In fact, he specifically denied them, not just failed to report, but denied them.
Yes, he denied active hallucinations at the time.
But in your interview in 2019, he changed that story to say that he'd been having hallucinations since he was 10 years old.
Not necessarily. He did not endorse to me that he's had previous hallucinations. However, at that time, when I asked him, he denied current hallucinations or current suicide ideation.
Well, excuse me, I want to be clear. In 2010, he denied having hallucinations, but in 2019, he claimed that he'd been having hallucinations since he was 10 years old.
I guess so. I suppose that's correct.
To your knowledge, the defendant consistently denied having hallucinations or delusions prior to killing his son.
Not necessarily. I don't know if I formally asked that question.
To your knowledge, the defendant never once reported having delusions or hallucinations prior to killing his son.
Not reported by him, but reported by his commanding officer.
You would agree that in your report, you indicated that his commanding officer had a reputation for bending the truth?
I do recognize that, and I did consider that.
So, to your knowledge, the defendant himself never reported any hallucinations or delusions at any point prior to killing his son?
Not at that time, no.
And to your knowledge, the defendant never accused anyone of being a member of the CIA prior to killing his son?
No, not at that, no.
No further questions.
Thank you, Mr. Soloway. Mr. Carlson, do you have any redirect examination of this witness at this time?
I do not, Your Honor.
Major Riley, we appreciate your time and your service and your testimony here today. You will be dismissed. Mr. Carlson, does the defense have any additional evidence they'd like to present?
Yes, Your Honor. The defense calls Officer Peyton Wentz to the stand.
Whenever you're ready, counsel.
Officer, where are you employed?
I'm a patrol officer with the Skelton Police Department.
The jury has heard that Mr. Ray was stopped by you at a DUI checkpoint in October of 2018. Was he stopped for being drunk?
No, ma'am.
Was he acting drunk?
No, he was not.
If he wasn't acting drunk, what concerned you?
The moment I started talking to him, he just seemed a little off.
When you say off, how did he look?
Well, he looked disheveled. His hair was all messed up. Eyes were glassy. Right away, I could smell this overwhelming body odor. Kind of looked like he had been in his car for a few days, maybe.
What did the interior of his car look like?
It was a mess. There was trash everywhere all over the backseat.
And in the first moments of your interaction, how did he act?
You know, he just seemed off. At first, he got really antsy when I asked for his license and registration, and he asked why I needed to see them.
Did he give you his license and registration?
Well, eventually, but he needed some convincing.
What happened after Mr. Ray gave you his license and registration?
Well, so as soon as I had his license and registration, I walked away to go run his plates. And then when I came back, he asked me if I was with the CIA.
How did you respond?
I told him no. I'm with Skelton PD, not the CIA. Yeah, I told him no. He didn't seem to hear, he didn't really seem to hear my response. He was just talking over me.
Was anything more said about the CIA?
Yes, he said he knew the CIA had been watching him because they thought he was a terrorist. He seemed totally paranoid. He kept saying there were sirens going off nearby.
Were there any sirens going off nearby?
No, ma'am, there were not.
Was this the last time that Mr. Ray brought up the CIA?
No, he brought it up again when I tried to get him to step out of his vehicle, and he just kept asking for my CIA credentials.
When you asked Mr. Ray to step out of the vehicle, did he comply?
Once again, not at first. I just kept showing him my badge and telling him I'm with Skelton PD, not the CIA. And at that point, he got out of his car.
Once he was out of the car, how did he behave?
So that's when his behavior changed. All of a sudden, he started acting like a zombie.
What do you mean by that?
Well, he was moving really slowly. He had this sort of blank stare on his face, and he wouldn't make eye contact with me at all.
Was he saying anything?
Yeah, just kept saying things like, I didn't mean to, I'm a good father. He started explaining how he was trying to get his son into shape and admit what he broke. He said his son needed to do jumping jacks.
How did his voice sound?
Well, he just kept repeating things in this really monotone voice.
Were these responses to questions that you were asking?
No, he wasn't really talking to me. It seemed like he was talking to himself, or I don't know, maybe nobody at all.
After he said that his son needed to do jumping jacks, what did he do?
Well, ma'am, he started to do jumping jacks.
You mean that on the side of the road, he was doing jumping jacks like we were taught to do in gym class?
Yeah, I mean, I told him to stand still, but he just ignored me. It's like he didn't even hear me.
When did that stop?
Well, eventually I pulled out my gun and I yelled at him to stop moving.
Was that successful?
Sort of. Except that he stopped doing the jumping jacks and then he started shaking his head uncontrollably. He sort of like put his hands over his head like that. And he started rambling to himself in this sort of quiet, frenzied voice.
After hearing and seeing this behavior, did you radio police headquarters about Mr. Ray?
Yes, that's when they sent Detective Booth to the traffic stop.
Did you tell Detective Booth about what you had observed?
I did. I told him that something seemed off, that Mr. Ray had a serious body odor, looked disheveled. I was surprised when they didn't send an EMT with him. I thought this guy needed medical attention of some sort.
Detective Booth testified that you drove Mr. Ray to the police station. How did he act when he was in your patrol car?
Well, he was calmer than before, but he was still crying and he was repeating the same things he was saying earlier over and over again.
What do you remember him saying?
I remember him saying, I'm a good father. He repeated that he messed up and that he didn't mean to do it.
Throughout the night of this arrest, was Mr. Ray ever seen by a doctor?
No.
Did you ever see anyone give him medical attention?
No, ma'am.
Officer, have you worked DUI checkpoints before?
Yes, I have.
Have you ever seen anything like Mr. Ray's behavior at any of those DUI checkpoints?
I haven't seen anything like that, no.
No further questions.
Thank you. Ms. Chandler, do you have any cross-examination of this witness?
Yes, Your Honor.
Whenever you're ready, counsel.
Thank you. Good afternoon, officer.
Good afternoon.
I want to start by talking to you about your job. You are a police officer.
Correct.
And you've been a police officer for 2 years.
That's correct.
You are not a psychiatrist.
No, I am not.
Right. You don't have a medical degree.
Certainly don't.
You cannot diagnose someone with a mental disease or defect.
No, once again, ma'am, I'm not a doctor.
Right. And I just want to be very clear. You're not here to give any expert testimony regarding Mr. Ray's mental state.
No, I'm here to just tell people what I saw.
Right. Okay, officer. I want to talk to you about 2 points in time. The first is before you had the defendant's license and registration, and the second is after you had his license and registration. Okay. Before you had this information, the defendant was squirrely.
That's correct.
The defendant was defiant.
Yes, he was.
He was not asking about the CIA at that point.
At the very beginning of our interaction, no.
He was not claiming to hear sirens.
He did eventually, but I don't think right away, no.
Right. Once you had his license and registration, he started acting paranoid.
That's right.
He started acting frantic, right?
Yes, he did.
And it is this license and registration that would tell you the defendant had a missing persons report out for him, right?
Yes, it's when we got the defendant's, we got Mr. Ray's information, and then we ran it, that's how we knew about the connection.
Right. So when you had this information that would tell you he had a missing persons report is when he started acting paranoid, in your opinion.
I suppose that's correct.
All right. I now want to shift to talking about the suspicious items you could see in the defendant's car. You saw some items that could be used for gardening.
I assume you're referring to the shovel. Yes.
Right. You saw a shovel.
Yes.
You saw a ton of black trash bags.
I don't know if it was a ton, but there was a fat box of black trash bags.
You also saw 2 jugs of bleach.
Correct.
And in addition to those items, you noticed that the defendant, he was really dirty.
Yes.
He smelled.
Yep.
He had stains on his clothes.
That's correct.
All right. I want to talk about your worry regarding the defendant's behavior, which you expressed on direct examination. You were worried about the defendant's behavior, right?
Yeah, he was acting very strange.
Right. You didn't call for a EMT that night.
No, I did not. I assumed a commanding officer would do that.
Well, on the phone, you didn't request for an EMT to come.
No, I didn't do that myself. No.
To be clear, that night you didn't get any medical attention for the defendant.
No, after my interaction with him, I took him to the station and then he was there.
All right, officer. I want to talk now about the admissions the defendant made to you that night. The defendant told you he didn't mean it.
Yeah, as I stated, yes, he did say that.
The defendant told you I messed up.
Once again, yes, he did say that.
The defendant told you I am a good father.
Correct.
The defendant, who we know strangled his 6-year-old son to death, told you he is gone. I can't believe he is gone.
Yes, that was one of the things that he said.
No further questions, Your Honor.
Thank you, Ms. Chandler. Ms. Gubernick, any redirect?
Yes, Your Honor, just briefly.
Whenever you're ready.
Officer Wentz, when did you graduate from the police academy?
I can't recall the exact date. I believe it was a couple years ago.
Prosecution said you had been a police officer for 2 years. That's correct. Would you agree with that?
Yes.
During your time in the police academy, did you have any mental health training?
I certainly did. Once again, I'm not a doctor, but I did receive mental health training on how to, identify people out in the field who may be suffering from a mental health problem.
Based on what you saw from Mr. Ray in the time before you took his license and registration, did you think that he was faking?
No, I don't know anything about that. I just thought he might have.
Objection, improper opinion.
Your Honor, if permitted to testify, this witness will just tell the jury what he saw in the moments before Mr. Ray handed over his license and registration. This is not an expert opinion. He's not opining on any medical diagnosis. This is just what Officer Wentz, as a police officer out in the field, saw Mr. Ray doing.
May I respond, Your Honor?
Sure.
This would require the witness to speculate into the mind of the defendant as to what he was thinking at the time and whether he was intending on faking or exaggerating these sort of symptoms or making up the CIA sort of stuff. So again, it would require the defendant to enter into the mind of the defendant, which 1, he's not an expert to be able to do, and 2, is also speculation.
Your Honor, if I may respond to the speculation argument.
Briefly.
Yes. My question was about Officer Wentz's perception, not about the mental state, not about what was going on in the mind of the defendant at all. This is just asking for Officer Wentz's perception of what he saw on the night of the arrest. Okay.
Well, I'm going to overrule the objection, but Ms. Chandler, if it does get into the realm of examination where you believe we're now getting into the defendant and his state of mind, please re-raise your objection at that point.
Officer Wentz, based on what you saw before Mr. Ray handed over his license and registration, did you think that he was faking symptoms?
No, he was just acting really weird.
No further questions.
Thank you, Ms. Gubernick. Officer Wentz, you'll be excused. Thank you for your testimony here today. Ms. Gubernick, does the defense have any other evidence they'd like to present?
No, Your Honor. With that, we're ready to proceed to closing statements.
Okay. Before we proceed to closing statements, why don't we take a brief 5-minute recess? And why don't we have the timekeepers for the respective parties confer just to make sure that we have an accurate accounting of the time before going into closing arguments. Court will be in recess for 5 minutes. Mr. Carlson, are you with us as well? There he is. Are the parties ready to proceed to closing arguments then?
Yes, Your Honor.
Yes, Your Honor, just a moment to set up the well.
Certainly, Mr. Soloway. And I understand that the prosecution has 12 minutes, 54 seconds remaining. Defense, 10 minutes, 11 seconds remaining. Mr. Soloway,
Yes, Your Honor.
whenever you're ready, sir.
Yes, Your Honor, I just want to make the court aware that I will be using demonstrative during closing. Defense has had an opportunity to review this, and they had no objections.
Okay, and before you start, Mr. Soloway, I'd like to remember the members of our jury to switch back to speaker view for closing arguments, so you only see the advocate that's actually speaking. And I'll be doing so as well. Counsel, whenever you're ready.
Yes, Your Honor. I pulled until he stopped screaming, until he stopped moving. Those are the words the defendant used to describe killing his 6-year-old son by strangling him to death with a belt. Those are not the words of an insane man. They're the words of a father who lost his temper when his son Nathan would not stop screaming for his mother and that he hated his father. As the prosecution in this case, we bore a burden. We had to prove to you beyond a reasonable doubt that the defendant killed his son Nathan and that he did so with malice aforethought. Now, malice aforethought, as the judge just explained to you, that just means that he did it intentionally. Members of the jury, the defendant punished his son for spilling juice on a laptop, and when Nathan wouldn't stop screaming for his mother, he wrapped a belt around his neck and pulled until Nathan stopped moving. That doesn't happen by accident. And you heard Detective Booth. Nathan didn't die right away. The defendant had to pull until Nathan stopped moving forever. And then he buried him in a shallow grave after realizing that he had no good way to dispose of the body. Then all of a sudden, after he kills Nathan, despite denying these symptoms for years, he starts to claim that he's hearing voices, starts accusing people of being with the CIA. Now, because the basic facts of his killing Nathan are not in dispute, make no mistake, the defendant has committed murder in the first degree beyond a reasonable doubt. But because those facts are not disputed, the defense has brought a plea of insanity. Now, the insanity defense is important in our legal system. There are people that have disorders that need treatment, that we shouldn't hold responsible for the things that they do. But when somebody fakes symptoms to try to take advantage of that legal system, it makes it harder for the people who really need help to get it. And that's what we have here today. Because when he realized he couldn't get rid of the body, the defendant started faking symptoms. Now, there are two parts to the insanity defense that the defense had to prove to you today. The first is that the defendant had a severe mental disease or defect. The second is that he either did not appreciate the nature and quality of his acts, or he did not appreciate that his acts were wrong. Now, the judge just read you the exact jury instructions. Use those for the specifics, but I want to break down each of those elements, starting with whether or not the defendant had a severe mental disease or defect. Now, you heard from two doctors here today, Dr. LaGreca and Dr. Riley. Dr. Riley claims that the defendant suffers from schizophrenia, but Dr. LaGreca reviewed Dr. Riley's work. Dr. LaGreca told you that what the defendant claimed to be delusions were in fact rooted in reality. the defendant's wife was cheating on him. That makes that not a delusion. The defendant claimed to have hallucinations, but Dr. LaGreca told you that these were the defendant's own thoughts, because again, they were rooted in reality. But more importantly, Dr. LaGreca told you about malingering. Now, malingering just means faking symptoms. As you heard from both Dr. LaGreca and Dr. Riley, the defendant consistently denied having delusions or hallucinations. And he didn't start claiming to have delusions or hallucinations not only until after he killed his son, but after he was interacting with the police. All of a sudden, he starts claiming that people are from the CIA. Now, if you believe Dr. Riley, if you ignore the fact that these symptoms showed up when the police started questioning him, and that everything else that we have here is based on things that the defendant said, well, your inquiry can't stop there, because a schizophrenia diagnosis, that's not enough. After all, if there are billions of people in the world, there are millions of people with schizophrenia. They don't all kill their children. So that brings us to that second part of the test for insanity. Whether the defendant did not appreciate the nature and quality of his acts, or whether he did not appreciate the wrongfulness. There's two parts to that. I'm going to start with that first one. That's the nature and quality of those acts. Now, to not appreciate the nature and quality, someone has to not appreciate the physical consequences of their actions. That's like if somebody's actually hallucinating and they pick up a squirt gun, point it at someone thinking water's going to come out, and they realize it's a real gun. There's no evidence here that the defendant didn't know exactly what he was doing when he pulled tight that belt around his 6-year-old son Nathan's neck and held until he stopped screaming, until he stopped moving. Because there's no evidence that he didn't appreciate the nature and quality, we turn then to the question of whether he understood that what he was doing was wrong. Now, the defendant wants you to believe that he was punishing his son for spilling juice on a laptop, that he understood that spilling juice on a laptop was wrong, but that at the time he did not understand that murdering his 6-year-old son was wrong. But there's more than that, because the first thing we have from the defendant before the evaluations, before his interactions with the police, are some searches. 3 searches that he made on October 18th. How to dispose of a body, whether bleach will destroy a body, bleach that was found in his car, by the way. But I want to focus on that first search. Countries that do not extradite for murder. Now, to extradite, that's a legal term. It means to send somebody back from a country into the United States to stand trial. Well, members of the jury, as the judge just told you, evidence that the defendant knew something was unlawful is evidence that the defendant knew what he was doing was wrong. There's no reason to search for whether or not another country would send him back to stand trial if he did not know that what he was doing was illegal, and therefore knew what he was doing was wrong. Members of the jury, it can be hard to understand why someone would do this. But the defendant, he's not an insane man. He's a father who lost his temper. He lost his temper because his son wouldn't stop screaming for his mother. And so he wrapped a belt around Nathan's neck and he pulled until Nathan stopped screaming, until he stopped moving. Find the defendant guilty of murder in the first degree.
Thank you, Mr. Soloway. Ms. Gubernick, do you have an argument you'd like to present?
Yes, Your Honor. Just 1 second to get adjusted.
Certainly.
May I proceed, Your Honor?
You may.
Timothy Ray didn't just lose his temper and decide to kill his 6-year-old son. He's not the cold-blooded murderer that the prosecution claims he is. He suffers from schizophrenia. Schizophrenia is a severe mental disease, and in Mr. Ray's case, one that's gone unnoticed, unchecked, and untreated for a really long time. And it's because of this that Nathan Ray is dead. Under the laws of this country, we don't hold people accountable for actions that are caused by severe mental diseases like schizophrenia. That's why today we raised an insanity defense. That means that as the defense, we had the burden to prove by clear and convincing evidence, which simply means that it was very probable that Mr. Ray first suffered from a severe mental disease, and second, that because of that severe mental disease, he wasn't able to tell right from wrong when Nathan died. I'm going to spend the majority of my time today talking to you about the first prong of that insanity defense, that Timothy Ray was suffering from a severe mental disease, schizophrenia. Today, we asked Dr. Riley to apply the facts and circumstances of Mr. Ray's life to the science of psychiatry. And that's exactly what she did. Dr. Riley had met with Mr. Ray back when he was in the military. She treated him before. She met with him again and evaluated him again after he was arrested. Dr. Riley was also the only expert in this case to interview people from all walks of Mr. Ray's life. She met with his father, his boss, his ex-wife. Based on all of these facts and all of these interviews, Dr. Riley was the only expert to faithfully apply the DSM-5 and to properly diagnose Timothy Ray with schizophrenia. You heard 3 indisputable facts about schizophrenia today. First, that childhood trauma is a known cause of schizophrenia. Second, that a family history of severe mental diseases is a known cause of schizophrenia. And third, that anxiety disorders that start in young men can worsen over time, eventually becoming severe mental diseases like schizophrenia. All 3 of these applied to Mr. Ray. His battle with mental illness started when he was just a child and worsened over time. His mother suffered from her own severe mental disease. She abused Mr. Ray as a young boy, bathed him in freezing water, often refused to feed him, and then she abandoned her 3-year-old son not long before she herself was committed to a mental institution. As he got older, Mr. Ray started to experience severe mood swings, just like his mother had. As a young adult, he had hallucinations. He was diagnosed with anxiety and depression so severe that he was medically discharged from his service in the military. By 2015, he was having paranoia. Voices in his head telling him that his wife was, quote, screwing around on him. Voices that got louder and louder in the months leading up to Nathan's death. He heard voices telling him that his wife and son were going to, quote, cut him up with a knife and leave him. All of this took a toll on Mr. Ray's daily functioning, manifesting as what the DSM calls negative symptoms. He wouldn't shower for more than a week at a time, would lock himself in the bathroom for hours. He was found crying in his cubicle at work on numerous occasions. By the time we get to the second factor of the DSM, it's clear that Mr. Ray's entire life had deteriorated. His wife left him because of this behavior. He couldn't even do simple tasks anymore, like take a shower. But the prosecution today presented you with testimony from Dr. McLagreca, who, as you heard, essentially cherry-picked the facts that aligned with the theory that the government wanted to present you with today. Their theory that Timothy Ray was not sick at all, that he was just malingering. In order to reach that conclusion, Dr. LaGreca ignored facts. He ignored statements of key witnesses. He ignored key dates. He ignored the topic of the CIA altogether. And members of the jury, you know that he did this every step of the way. Not only were none of these facts mentioned during direct examination today, they weren't included in his 7-page report. Think about that. Dr. LaGreca testified before you today and wrote a report, and nowhere did he mention Jessica Ray's own words, quote, "I never should have left Nathan with him when he was acting strange. I knew he was going crazy." Now, aside from presenting you with an expert who was just casting aside facts, prosecution also failed to preserve key evidence in this case. Detective Booth, the lead investigator on this case, the biggest case of his career, couldn't have been bothered to preserve the audio and video from his interview with the defendant on the night that he was arrested? By failing to preserve this evidence, Detective Booth effectively destroyed the only evidence that would have allowed everyone in this courtroom to see what Timothy Ray looked like, how he was acting, what his voice sounded like. What the prosecution left you to rely on was the memory of this detective alone. The memory of this detective who just 2 months after the incident couldn't remember that Timothy Ray asked him if he worked for the CIA not once, not twice, but 3 times. Now, 2 years after that incident, the prosecution is asking you to rely on that man's memory alone as evidence that Timothy Ray is sane? Dr. Riley gave you all the facts you need in this case. The prosecution talked about the 2010 diagnosis, but the truth of the matter is, Timothy Ray had gotten worse, and Dr. Riley had more information. Schizophrenia is a very complex disorder. But in this case, the diagnosis is clear. Timothy Ray suffered from severe schizophrenia in October of 2018. Now, a lot of those same facts that prove the first prong of the insanity defense also prove the second prong, that Timothy Ray couldn't tell right from wrong when Nathan Ray was killed. I'm not going to repeat all of those facts for you again, because you know them. But what I will repeat for you are Timothy Ray's own words on the night that he was arrested. Quote, "I didn't mean for any of this to happen." Quote, "I didn't know what was happening." Timothy Ray didn't know if what he was doing was right or wrong. He was just listening to the voices that had been controlling his life for so long. Now, the prosecution wants you to believe that because Timothy Ray took time to cover up some of these facts, that he knew right from wrong. But use your common sense. people who are really trying to cover up their tracks don't put their son's dead body in the car and drive around for days. They don't forget to delete their internet search history. They don't just cruise up to the police at a DUI checkpoint with a dirty shovel and bottles of bleach in their back seat laying open for anyone to see. That's what someone with a severe mental disease does. And that's why the fact that Timothy Ray was insane just makes sense. Because normal parents don't kill their 6-year-old sons over a glass of spilled juice. And they certainly don't, as Timothy Ray said to Dr. Riley, say that they would have done it even if the police had been watching. Prosecution gets the last word in this case. That means that they have one last chance to give you answers to the important questions. There are easily a dozen unanswered questions in this case, but I'll leave you with just 2. Ask the prosecution why you should trust Detective Booth when he failed to preserve those tapes and when his memory just can't be trusted. Ask why the prosecution acts like Jessica Ray was lying when she said that her ex-husband was going crazy. And if those answers don't come, or if they simply don't ring true, that's how you'll know that severe schizophrenia killed Nathan Ray. Unnoticed, unchecked, and untreated schizophrenia. And that's how you'll know that Timothy Ray is not guilty by reason of mental insanity. Thank you.
Mr. Soloway, do you have a rebuttal? Mr. Soloway, you might be muted.
Can you hear me now, Your Honor? Oh, Your Honor, you are muted.
I can't, Mr. Soloway. You can present your rebuttal argument when you're ready, sir.
Yes, Your Honor. Apologies for the technical difficulties. No one is disputing that the defendant in this case is troubled. It really is hard to understand why someone would kill their child. But the unfortunate truth is people do kill their children even if they're not legally insane. The defense is right. There are unanswered questions here. But those questions, it's the burden of the defense to answer them. They have to prove to you by clear and convincing evidence that the defendant had a severe mental disease or defect and that he did not understand that what he was doing was wrong. Some of those questions, like why did Dr. Riley ignore the fact that symptoms suddenly showed up after the defendant was interacting with the police? Questions like why did Dr. Riley ignore malingering concerns despite the fact that the defendant was in serious legal trouble? The defense answers these questions by saying that the defendant is schizophrenic, but we know that's not true. We know it because 3 doctors evaluated the defendant after he killed his son. Dr. Riley, Dr. LaGreca, and Dr. Narasimhan. The only one of those who diagnosed the defendant with schizophrenia is the one the defense brought here today, Dr. Riley. Now, the defense wants to talk about unnoticed, unchecked, and untreated. Well, you can't notice something that doesn't exist. You can't check something that doesn't exist, and you certainly can't treat something that doesn't exist. Something that did exist in this case was Nathan Ray. the defendant's 6-year-old son, who, because he was screaming for his mother, the defendant wrapped a belt around his neck and pulled until he stopped screaming, until he stopped moving. Find the defendant guilty, because he is.
Thank you, Mr. Soloway. Well done, everyone. Congratulations on a clean round. We've now completed closing arguments. If I could ask the jurors to please complete and submit your ballots. And once ballots are submitted, I will ask everyone to stay on the Zoom so we can give some brief comments before we dismiss you for the evening. And for our 3 jurors, once you have had an opportunity to complete and submit your ballot, if you could just let us know.
Mine is ready. It's in.
Excellent. Juror Benjamin?
Give me just 2 more seconds. I want to just double check. I make sure everything's in.
Please, no rush.
All right. Mine is in as well.
And Juror Quinn?
Mine submitted.
Excellent. So that completes the trial. We'll begin comments. And if we just a reminder to our jurors to keep your comments to 1 per side. That's been requested by the organizers of the competition. So Ms. Valeri, why don't we start with you?
Oh, so you want us to do 1 per side?
Yeah, that's the limitation that we've been given by the organizers, just to make sure that we keep a relatively quick timetable so that we can dismiss the students so they can find out who's competing tomorrow.
Okay. Well, I didn't do it 1 per side, and I'm going to make this really quick, okay? Number 1, opening statements, make sure that they're argument, not argument. You should be telling them what the evidence is going to show. Number 2, when you go to ask questions, please finish with a correct. So, isn't it true, sir, that he used a belt? Correct? You didn't finish your questions, and it was on every answer. And number 3, some of them were a little bit too long. Less is more. So when you go to ask that 3rd and 4th and 5th extra question, just don't ask it. So those are my 3 points.
Thank you, Ms. Valeri. Mr. Benjamin?
All righty. Thank you so much. So first and foremost, I want to say you guys are absolutely incredible. Great work. Great work. As far as my comments go, I'll start with the defense. I think the defense, you handled the emotion that the prosecution presented very well, but I would also agree with my colleague in saying that less is more. At some points, I think that the defense had a really killer line in there, or real killer question, and instead of just ending it on that killer question, they tried to fish for more. Less is more in these kind of situations. As far as the prosecution goes, I would say that although emotion was a very, I don't want to say obvious, but blatant, strategy here, I think that you guys handled it in a different way, in a way that wasn't just presenting a ton of emotion to the jury and expecting the jury to just feed off your emotion. It was a matter of, presenting the emotion in somewhat of an authentic way, in a way where I think the last line that the prosecution walked off on is he's guilty, because he is, right? And I think that the way you played off the emotion was very impressive, and not cliche. Oh, also, I have like a ton of detailed notes. If any of your coaches want to reach out to me, I love trial work. So I took a ton of notes. If you guys want any of them, just reach out.
Mr. Quinn?
Thank you. I could repeat Ms. Valari's comments and Mr. Benjamin's comments because basically those are the same kind of comments that I had. Less is more, and be careful of the procedure in court. You may find yourself caught where objections are being sustained. So I'm going to leave it because I have coached or attended as a scoring juror or a judge in these mock trials at the high school, college, and law school level now for 5 or 6 years or more. And I've been practicing law and litigation in Philadelphia for 43 years. So the thing that I want to leave you with is actually not my own, is from another mock trial judge, and that is that always have a plan B. In this particular case, there were several objections that were made. One of them that just sticks out is the objection that if somebody hears a voice that's not there, is that hearsay? That can backfire on you, and that can backfire on your entire defense. You need to find a way to get the voices that are being heard into evidence, and it really didn't become a problem for you in this case, but it could have. So I think that you need to have a plan B. How are you going to get that, those voices into evidence if you have a judge that thinks that's hearsay? And so always have a plan B for every piece of critical evidence that you need to get in to prove your prosecution or prove your defense. Other than that, I think that this was a very good trial and all you did an excellent job.
Yeah, I should have said that too. It was a very good trial, very close in calculations. I would just make sure I finished my questions with a correct when it begged for it. Judges will stop you if you don't do it. They'll say you're making statements as opposed to asking questions. All right.
Thank you, everyone. I'll leave you with this. It was a great round, very smooth. You were all very professional and very prepared. I thought your use of the technology was great and very well done with such a difficult environment and putting on a difficult trial on Zoom. So best of luck to all competitors. Best of luck to you all going forward.
Sorry.
Ms. Valeria, any
I'm sorry,
parting comments?
Very, very well prepared. That you can give them. They really, really, and if they end up trial lawyers, if they're well prepared, they'll all be winners. When do we find out, or do we find out if they win? We don't.
So I believe the announcements have been pushed back because some other courtrooms are running a little long. Hopefully in another hour or so, we know who will be advancing to the next day. And then tomorrow we will announce the champion. So good luck to all of you. Great round again. And thanks for your participation today. Have a nice evening.
All right. Bye-bye, everybody.
Thank
Bye.
you, everyone. Have a good one.